People, ex rel. Rankin v. Brann.
Good evening, Your Honors. May it please the Court. For the appellant, Assistant District Attorney Danielle O'Boyle from the Office of Melinda Katz. Your Honor, may I reserve 2 minutes of my time for rebuttal?
Yes.
Thank you, Your Honor. Subsections 1 and 2A of Section 53060 of the Criminal Procedure Law have distinct purposes, analyses, and consequences. In this case, however, the Appellate Division acknowledged the stark contrast between those two subsections, but incorrectly held that a court is required to apply subsection 2A whenever the court considers...
I don't take it that is what they held. I thought they held if you're going under 1, you have to make a record, essentially, of risk of flight. If you're going under 2A, it's a dangerousness assessment, right?
No, Your Honor. The court acknowledged the difference between the subsections, that subsection 1 would require a risk of flight analysis,
right,
and that subsection 2A would require a dangerousness analysis.
And they said you didn't make a risk of flight. There was no risk of flight finding under 1 on this record, as I read that opinion. They don't say you never can use 1. They just say you improperly used it here because the findings aren't there to support a risk of flight.
Well, Your Honor, the Appellate Division didn't actually acknowledge that the lower court here did engage in a risk of flight analysis, as did the people. But what the Appellate Division held was that if the court is relying even in part on the defendant's commission or alleged commission of new offenses, then it is required to automatically apply subsection 2A. And here, the lower court made very clear that its finding was based upon a showing of good cause, that the least restrictive means to ensure the defendant's return to court.
Wait, so you understand the Appellate Division to have held that if the felony that's committed while the defendant is out is one that itself is strong evidence of risk of flight, they still can't use that to prove risk of flight. So the person's trying to hijack a plane, something like that.
Yes,
Forge a passport to get out of the country.
Yes, Your Honor. The Appellate Division's decision, the way it reads is that the court would be precluded from exercising its authority under subsection 1 if the analysis in any way turns upon the defendant's commission or alleged commission of this new offense. And that's where it missed here, the fact that the lower court very explicitly made a finding that this was the least restrictive means to ensure the defendant's return to court and did not in any way invoke dangerousness. And that's the case for the people's application as well.
It seems to me, reading the Appellate Division decision, that they said, since the people applied for remand on the sole basis that the principal was accused of committing a violent felony offense while at liberty on the underlying felony, the court was required to apply 2A. That means you went arguing that violent felony or specified felony under 2A, you're stuck with that, and you can't use 1. If, I think as the Chief Judge is getting at, you had said there are certain factors here around the commission of these specified felonies, then you could use 1 and have a finding that those factors led to this risk of flight. But you didn't do that here. That's how I read the Appellate Division.
Well, Your Honor, if I could address that in 2 parts. First, I think that the people certainly did that here in that their analysis and their request was made for the purpose of a least restrictive means analysis. The people undoubtedly mentioned the new arrest, but they specifically stated that they were making their application under subsection 1 and using a risk of flight analysis. But the court's ruling makes that even clearer. The court states that that subsection can apply because we're dealing with a qualifying offense, so certainly we're in the realm of something that's permissible under the statute. And then it goes on to discuss a number of bail factors that are relevant to a risk of flight analysis. Certainly the court...
So could it be said here that the 2 sections got mushed together?
No, Your Honor, because if there had been some combination of the 2, then there would have had to have been a consideration of dangerousness made, and neither the people nor the court cite that.
So how does the court's power come into play with respect to the bail as to what subdivision 1? Does it have to be a request of the people? Does the court have its own power to review? How does that work?
Under subsection 1, it states that it can be upon motion or request of the people or otherwise. That's the language specifically stated in subsection 1. And here, the court makes clear that it's not just the subsequent arrest, the 3 violent felonies.
So can the court make its own ruling invoking 1, despite what the people may have asked for the sake of argument?
Yes, absolutely, Your Honor. And that's Certainly, the court was clearer here than the people, admittedly. The people made their application under subsection 1, but I admit that there was some confusion initially.
Where in the court's finding, because I'm looking at A55 of the record, and it says, based upon my review of the bail statute, I believe the least restrictive means to ensure the return is remand based on the defendant's repeated violations of the conditions of release, which is by committing these felonies, that he not be rearrested. And going beyond rearrest, I believe that the indictment provides good cause for the application here.
Yes, Your Honor. The court also discussed the defendant's criminal history, the fact that he had 2 prior misdemeanor convictions, that he had been found to be a repeat parole violator while he had been on the course of parole. During the course of his...
That was all known before, or that's new?
It's certainly not new at the time this application is being made, but those factors are still part of the total analysis of that defendant.
What's the record of what changed beyond he violated the conditions of his release and he got arrested on this felony?
Those were certainly the changes, Your Honor, but in terms of whether, the analysis is whether the people have shown good cause to modify that order. So all of those factors together, the people had made that showing and the court made that finding. Here, even if we took aside the factors that were known to the court previously about the defendant's history, his status as a parole violator, all of that, and we just looked at the fact that he had been arrested for several new violent felonies, undoubtedly that shows an inability to abide by the court's order to not be rearrested.
But why isn't that 2B?
It could be 2B, Your Honor, but it didn't have to be.
But I thought that if you're just relying on the fact of rearrest, it has to be 2B. It's the same way as 2A, because when you actually, one, I think the statute requires when the defendant's notified that you can be remanded if you violate the conditions, it says you're entitled to the 2 protections, right?
Yes, Your Honor, but nothing suggests that that is the exclusive means by which a court can consider these new arrests. And the other factor that's
No,
important...
they can consider them under 1, I think is the point, but it has to
Yes.
go to risk of flight.
Absolutely, Your Honor. And I think both the people and the court did make that clear here, because it was not simply that the defendant committed these new offenses, but the people highlighted the strength of the evidence in each of these cases, that there was DNA evidence in both the underlying case as well as one of the new cases, that the defendant had been identified in photo arrays in 2 of the cases.
The legislative history behind the amendment from way back is that the people were frequently, and courts were agreeing, and allowing people to be held on risk of flight when really it was dangerousness. And so this was a modest but important adjustment to the statute, right, to allow dangerousness to come in, but to eliminate the sort of fiction that we were holding people for risk of flight when really the issue was dangerousness, right? And there's an amendment that came in at the same time to subsection 3, which is, I think, what Judge Garcia was getting at a little bit, that then requires notice to be given to the defendant that if you, this is as a result really of the amendment, if you violate by committing a felony, you're going to go back, and you get a hearing there. It references the right to a hearing.
Yes, Your Honor. However, the hearing requirement was added based upon the concern that there would need to be this heightened due process protection when a court were, for the first time and uniquely, invoking the concern of dangerousness. And certainly, we're not
Correct,
contesting
but that's
that.
coupled with the idea that we're going to remove these ones that are sort of being called risk of flight that are really dangerousness, and we're going to provide that protection for them.
Yes, Your Honor, I certainly understand that, but in this case, if we use this as an example, there was undoubtedly an incentive, an increased incentive to flee based upon these new charges. There is significant increase in his sentencing exposure. These are all violent felonies.
But if that's enough, that kind of reads the amendment out of existence.
No, Your Honor, because there would certainly be circumstances where a defendant could have committed subsequent violent felonies, but is not found to be a flight risk.
So again, when I asked you earlier, so you're suggesting that the factors that are required for 2 can in some way impact or apply under 1?
No, Your Honor, I am not suggesting that, and I apologize if that was at all unclear. There could certainly be some overlap, and if the court in any way here made a finding of dangerousness, even if that was only part of the analysis.
No, not a finding of dangerousness, but relying upon the new arrest.
Well, I think...
Or factoring that in.
But the fact of the new arrest, so long as that is tied to a risk of flight analysis, and genuinely so, then subsection 1 would be appropriate to be
Yeah, but
applied.
it's the genuinely so, I guess, that worries me a little bit, because if the idea is you commit a bunch of violent felonies while you're out, and because your sentencing exposure now is much greater, that's an additional risk of flight, that's going to be true pretty much every time that you satisfy that, the condition of 2, the amendment. So you're not going to really need the amendment if you could always put that under dangerousness.
Your Honor, I see that my time is up. If I could have
Yeah,
leave to
please.
answer.
Yeah.
That there would likely, with the case of new violent felony arrest, there would certainly be, in most cases at least, an increased sentencing exposure. But I think it's important to note that the strength of the evidence should in fact be considered for a good cause determination. Certainly, we at least have, even without a hearing, there is an opportunity for the defense to be heard, to make arguments, and there's an instrument providing reasonable cause to believe that that offense was committed.
And adding Section 2, did it change the court's ability to act under Section 1?
No, Your Honor, and if it had, the legislature could have put that in the statute, in either subsection 2A or in subsection 1. In subsection 2A, currently it states it shall be grounds to revoke the order. It does not in any way state that it's the exclusive grounds. And in subsection 1, the legislature could have also added language that said except as provided in subsection 2. So it does not change that.
May I clarify your interpretation of these subsections in this sense? Subsection 1 is discretionary, correct?
Yes, Your
Court
Honor.
need not revoke.
Yes, Your Honor.
Okay. Do you view subsection 2 to be mandatory because it says shall be grounds, or is there still discretion there for the court to choose not to revoke?
I think that one is a little bit complicated, Your Honor, but I think that there is some discretion that the court now has the option under the new amendments to either remand the defendant or impose bail, which is something slightly different. But it brings up an interesting point, because I know respondent contends that the prosecution will always and inevitably seek to modify an order under subsection 1, and that would always be preferable for the prosecution. But when we're dealing with subsection 1, the defense actually has an opportunity to draw a fuller picture for the court as well, because under subsection 2, we're dealing exclusively with whether the defendant committed this alleged offense, which is why we have that extra
Okay, so
hearing.
just to be clear, I'm not sure I understood your answer to my question. Is 2 discretionary or mandatory?
I think it would be mandatory for the court upon the finding of reasonable cause to believe that the defendant committed that offense.
Appreciate that, thank you.
Under subsection 1, though, Your Honor, the defense would have an opportunity, as counsel did in this case, to argue about his minimal criminal history or lack thereof, his ties to the community, and other traditional bail factors. So it's not that that would always be favorable to the prosecution. And just to briefly conclude, I know respondent contends that, and this gets back to Mr. Chief Judge's question earlier, if the prosecution were to merely utter the words risk of flight, that we can somehow automatically transform into a subsection 1 analysis what should otherwise be a subsection 2A analysis. But it's not that, and I think what the court did here really illustrates that there should be an expectation that the court will do what it's supposed to do and hold the people to their burden, that there has to be a finding of good cause and a genuine increased incentive for the defendant to flee. Thank you, Your Honors.
Should I wait, Your Honors, or should I?
Ignore the
no,
judge
okay.
behind the screen.
Okay.
Hopefully we'll be able to rejoin Judge
Yeah,
Halligan.
maybe she's hearing it.
Good evening, Your Honors. May it please the Court. Ariel Reed of the Legal Aid Society on behalf of Mr. Waller. As evidenced by my adversary's arguments, the prosecution seeks this court's blessing to rely on circumstances to revoke someone's liberty.
And I'll ask you the same question I asked your adversary. Do you read subsection 1 as discretionary and subsection 2 as mandatory, or both are discretionary?
Your Honor, subsection 1 is certainly discretionary. Subsection 2, as the defense, we're always going to argue, judges, you don't have to revoke someone's bail based on this. It does use different language, shall be grounds versus may. I think
So when Subsection 1, it existed before 2,
Yes, Your Honor.
and when 2 was created, was the court's power taken away by that?
Your Honor, I think that that is a question that we can maybe zoom out a bit and talk about the structure of the statute to answer that question. The legislature has crafted a really straightforward and harmonious framework for CPL 536C.
Did they specifically impact the court's power under 1? And
Your-
if so, indicate where and how?
Yes, Your Honor. So I think for that question, you have to look at the canon, the canonical principles of statutory construction, which say that when you have a specific and a general provision of the statute that both apply to the same circumstances, it's the general or the catch-all provision only applies where the specific provision does not. And so if you accept that canonical principle of statutory interpretation, if you have a situation in which a particular subsection or a particular circumstance can apply under both subsection 1 and subsection 2.
So can both subsections apply here?
I don't think they do, Your Honor, based on this record, and I'll explain.
Let's give a hypothetical, I think going back to what the chief judge said. Let's say you have one of the qualifying offenses under 2A that involves a violent robbery of blank passports. And there's certainly an implication that the defendant plans to use these blank passports. Assume it's a qualifying offense under 2A. Could you not argue risk of flight based on the fact that this defendant committed a robbery of blank passport forms?
No, Your Honor, you could not, if you're the only purpose of seeking a modification of this curing order is because the accused allegedly committed a new violent felony offense.
It's because the circumstances of that felony indicate an increased risk of flight.
And Your Honor, I think that goes into why subsection 2 exists, because even if you're going under subsection 1, and I want to be clear here about what the statute allows to be considered under subsection 1 and what it doesn't. My adversary mentioned strength of evidence and sentencing exposure. Both of those were factors that courts were allowed to consider in the bail statute prior to 2019. In 2019, the legislature excised weight of the evidence, and the legislature excised
Is there
strength
evidence
of the...
that was done to eliminate them from consideration in the legislative record?
Your Honor, there is. We can, if you look at some of the statements that were made about, I believe it was Senator Montgomery who said that people are spending more time in jail.
So was Section 1 then changed?
Section 1 was implicitly changed, Your Honor, in the sense
But not
that
explicitly?
Section 1, as my adversary concedes, is based on modifications that go to the original bail factors, of which
It's
sentencing
a power
exposure.
that a trial court has had for a number of years, and the creation of subsection 2 didn't change that.
Your Honor, again, that particular question, I think, can only be answered by the principles of statutory construction. So
So can the court act under 1?
the court can act under 1.
And it also can act under 2?
I want to
Recording in progress.
I want to use this case as an exemplar of this, Your Honor. So Mr. Waller here, no dispute that he got rearrested multiple times on violent felony offenses, which the plain language of subsection 2A explicitly addresses. The prosecution, in their application, stated also explicitly, and I'll read from the record here, page, I believe it's A47, in their application, they said, while out on a violent felony offense on bail, the defendant then committed 3 additional violent felony offenses, and we believe the least restrictive means in order to assure his return to court is remand. So basically what the prosecution did below is say, we're relying on the fact that he got rearrested, and we're just
What
going to...
does on the court's own motion under subsection 1 mean? The other factors that the court could consider.
Yes, Your Honor. Subsection 1, I think the way to think about this statute is subsection 2 has explicit factors that the court considers, and then subsection 1, there's a wide universe of things that can come into play in any given case.
Let me try it this way. Tell me why the court could not, under these circumstances, act pursuant to subsection 1.
Your Honor, the court could not act pursuant to subsection 1 under these circumstances because the basis, as the appellate division held, the basis for revoking Mr. Waller's bail in this circumstance was the commission of a new violent felony, which is...
So was that the people had to tell the court what it wanted, so the court didn't have the right on its own to act under any section other than the one that the people asked for? Is that your argument, and that they asked for two?
No, Your Honor. My argument, if the court had some other grounds based on, a risk of flight analysis that the court had
What
wanted
about
to...
those other factors that the court did mention?
Your Honor, as Judge Garcia noted before, those were all factors that were before the court originally. The court knew about Mr. Waller's criminal history. The court knew about his
So it couldn't evaluate them now in light of new circumstances that occurred?
Not if the new circumstance, Your Honor, is a specifically enumerated factor in the statute that is specific to the particular circumstances in this case. And I want to note here...
The people in their argument on where you were reading from said, we believe the least restrictive means in order to assure his return to court is remand. They didn't say, we believe he's a danger to the community because when he's out, he commits felonies. They said in order for him to return to court, we believe the least restrictive means, I know that is not applicable now, but then it was, is remand, and the court agreed and did it according to that argument. So I'm having trouble saying that this is not a risk of flight argument that fits squarely into one.
Your Honor,
I mean, it might be two as well, but I mean, that's a legislative issue, that we have two avenues through the legislature to set bail. But I don't see how we can argue here that to assure his return to court is somehow transformed into a dangerousness argument. That's my problem here.
Yes, Your Honor, and there's a couple of points I want to make to that. And I think the circumstances here are informative because Mr. Waller, as we said, he's picked up new arrests. He's gotten rearrested 3 times on violent felonies. He continued returning to court. He didn't miss a court date. There was no allegation that he was, not abiding by the responsibility to return to court, which is the only purpose of a modification under 530-61.
The court couldn't factor in that the fact that he's collecting additional charges could now cause him in the future not to appear?
No, Your Honor, and the prosecution hasn't been able to establish a reason why outside of factors that have explicitly been removed by the legislature. And again, if we are abiding by longstanding principles of statutory construction and legislative intent, the legislature removed strength of evidence and sentencing exposure as factors, and the prosecution is relying on those excise factors to say, well, if somebody gets rearrested on a violent felony offense, necessarily their sentence is going to be increased. To Chief Judge Wilson's point, that's going to apply in every violent felony, and in which case...
Your white light is on, so let me just ask you perhaps questions in a different vein here. Subsection 2, as Judge Garcia already pointed out, you've got this hearing requirement.
Yes, Your Honor.
What's the purpose of the hearing?
The purpose of the hearing, Your Honor, is to establish that there's reasonable cause to believe the person actually committed the offense that they were rearrested
That is different, is it not, from subsection 1? Or does the good cause standard in subsection 1 mean that the judge must be persuaded that indeed this person likely has committed the crime with which they are charged?
Your Honor, I think that is different, and I think that's the point in why the legislature has enacted this protection, because, my adversary will say somebody gets rearrested, like I think the example used was they were forging passports. The purpose of a two-way hearing is to provide a reasonable cause to believe that they actually were forging the passports. Under subsection 1, for instance, the prosecutor could come in and say, they got rearrested for forging passports, good cause, go to Rikers. Under subsection 2, the court is required to actually hold an evidentiary hearing at which the prosecution, if, they can provide the grand jury minutes showing that the person got indicted.
Do you want to go back? I'm sorry, go ahead.
Let me just follow up.
Yes.
So under the analysis you're now advocating for with respect to the hearing under 2 and how 1 would work, would it be possible for the prosecutor to proceed on 2 and not persuade the court based on the hearing that satisfied that reasonable cause standard, and then come back to the well under 1? Because you are saying, of course, is a much lower threshold. Could
Your
they do
Honor-
that? And then argue risk of flight as opposed to whatever would be the standard as you see it under subsection 2.
Your Honor, if the prosecution failed to meet the reasonable cause standard under subsection 2, such that they couldn't revoke bail on that basis, if they have some other grounds to establish that the person is a risk of flight, of course they can come in the future and make an argument based on why that person is a risk of flight, but that argument cannot just be...
If you haven't persuaded the court under this reasonable cause standard, that maybe there's a likelihood that he has committed the crime with which they are charged.
Yes.
How would you satisfy the good cause? On the fear that even though the defendant believes that they will be found innocent, nevertheless, there's a risk that they might be found guilty, and that's good enough?
Your Honor, I think, the standard under subsection 2 is not that high. It's just, can you get an indictment? If you got an indictment and you show your grand jury minutes and the grand jury minutes establish reasonable cause to believe the person, committed the offense, then there's no question that...
But do you think that's a different standard from good cause in subsection 1? I mean, it is different phraseology.
It is different phraseology, Your Honor, and I think this case illustrates the importance of that difference in phraseology, because the prosecution, despite the fact that Mr. Waller had continued coming to court despite racking up new arrests, which I will note here, 2 of the 3 were dismissed. And so even though the prosecution said in their initial application, oh, we have overwhelming evidence, oh, he's facing 25 years, 2 of the 3 charges were dismissed, and they offered him a sentence of 2.
And is it your argument that the subsection 1 standard is more lenient than the subsection 2? Because the way you just described it, it sounds pretty easy to prove under subsection 2. The fact of an indictment alone would get you the reasonable cause to believe that the crime was committed.
Your Honor, I don't want to suggest that it's easy. I mean, if the prosecution...
No, I'm saying easier.
I don't think that is easier, and I think the fact that the prosecution is trying to avoid having to prove reasonable cause suggests that it's not easier. Under subsection 1, there's really no requirement other than a showing and good cause. Under subsection 2, the prosecution actually has to establish reasonable cause to believe that the person did the thing that they are seeking to put them in jail for.
But didn't you just say just a moment ago that really all you have to do is say he was indicted?
In many cases, Your Honor, if they've gotten an indictment, then sure. I think in this case, at least one of the cases, they were never able to get an indictment for. And so if that had been the only case that they were relying on, the statute allows for them to do a preliminary hearing, and I think that's important here too to note, because CPL 18080 requires that if the prosecution is unable to establish reasonable cause within 5 days, then if somebody's held in, they have to be released.
Can the defendant call witnesses at this hearing?
Yes, Your Honor. The defendant can call witnesses.
Can they call the grand jury witnesses?
The statute allows for the prosecution to introduce grand jury minutes
I
in lieu of
understand that.
witnesses, but I'm not sure if...
If you're having this hearing, can the defendant say, I either want a witness or I want the transcript?
Your Honor, the hearing does allow for, yes, the defense to litigate that
So maybe it's a gang case and you're facing mandatory life for gang murder. Would there be a reason the people didn't want to go under 2A then and put their grand jury witnesses in?
Your Honor, I think if somebody's charged with, gang murder and is facing a life sentence, they can just ask for bail on the gang murder case. And I think that's the other point here, is that the prosecution has, in this case, and in all cases in which someone's charged with a violent felony, the prosecution, if they believe that the person is a risk of flight, they can ask for bail on the new case. They don't have to go back and try to finagle modification on the old case. Violent felonies are bail eligible in the first
I know, but if you're a
instance.
judge and you have exercised your inherent power and authority to let someone out on bail, and then they violate a condition of bail, are you saying that the judge doesn't have the inherent authority under 1 to revisit the initial ROR and say, because you didn't put on your ankle bracelet, because you didn't go to a DV program, I am withdrawing and setting bail? Can a judge do that under 1?
Your Honor, for the violation of conditions, there's actually a separate subsection of the statute that addresses that, and that's CPL 51040
So
sub
let's say
3.
it's
And that also requires an evidentiary hearing.
a new arrest for a nonviolent
Yes, Your Honor.
that pertains to flight, right? That under 1, a judge could say, I'm going to remand or I'm going to set different bail conditions without a hearing, but on a violent felony, a hearing is required? I'm just trying to say, like, what are you asking us to say? That a judge can't modify an order on a subsequent charge ever?
No, Your Honor. So, and to that particular point, the felony offense, nonviolent felony, that's actually addressed by subsection 2B, and that's the important part. The legislature has picked out specific circumstances that may come up in a case when somebody is released and said, if these things happen, then this is what you do. If none of these things happen and you're relying on something else, then you can proceed under this catch-all provision.
But you're making it sound like it's an either or, and to Judge Troutman's point earlier, doesn't the court in its inherent authority, isn't it allowed under 1 to exercise that authority in more circumstances? It might be that they can also work under 2, but it's not an either or, but you're saying it is.
Your Honor, it is because, and again, it goes back to the statutory construction piece. If, let's say, it's a new felony arrest, and the prosecution's arguing that it's relevant to risk of flight, but also subsection 2B says if you're out on a felony and you pick up a new nonviolent felony, you have to have an evidentiary hearing. So the statutory scheme that the prosecution is advocating for is one in which you have a circumstance that applies to both 1 and 2, and it's basically up to the prosecution to decide, I don't really feel like doing an evidentiary hearing here, so I'm going to go under 1.
I think you're simplifying the legislative history, right? Because 2B was introduced so that the people could ask for bail under a dangerousness. It expanded, not limited, the possibility of bail.
Your Honor, 2B actually was introduced in 2019, and it has nothing, it's not a dangerous thing, or even under 2B.
2A, I'm sorry.
Yes.
2A, I misspoke.
And I think that's important because even under 2B, the court is required to consider to reset bail based on a risk of flight to avoid prosecution. So risk of flight to avoid prosecution also appears in subsection 2. And I think that's why it's important to reiterate here that when you have 2 different provisions of the same statute that apply to the same facts, legislative interpretation, years of legislative interpretation suggest and require that you apply the specific provision over the general provision.
And here, which one did all of what you're saying require the application? Only 2. Is that what you're saying, that the court had no ability to review the status of the defendant's release under subsection 1?
Your Honor, my point is that if the prosecution had wanted to rely on something else that wasn't specifically enumerated in the statute, they could have. They could have chosen any other reason to...
So the prosecution failed to ask and proceed under the right section. Is that your argument?
Yes, the prosecution...
And that the court had no ability to do anything but proceed under the section that they did ask for. Is that your argument?
My argument, Your Honor, is that there was nothing here nothing new, nothing to modify a securing order other than the fact that the client got rearrested. And the statute is clear that if the client gets rearrested on a violent felony, that it must proceed under 2, both based on the plain language of subsection 2.
So the court could have acted under 1, if there were facts sufficient to establish it.
If there were some other, yes, Your Honor, unenumerated circumstance. And just briefly in closing, I want to, again, highlight and urge the court to also look at the plain language of CPL 51030, which also says that when somebody's being released on a felony, the judge is required to tell them, if you get rearrested on a felony, you are subject to revocation under subsection 2. So this is in 2 places now that the legislature has indicated that subsection 2 is the appropriate vehicle here. And so we would just ask, Your Honor, as the appellate division below held,
But do you read that section to mean that the court will not proceed under 1?
I do, Your Honor. I read that section to say that if this particular circumstance happens, which is a felony rearrest, then subsection 2, you face revocation under subsection 2.
May revoke and may be authorized? There's a lot of mays in there.
Yes, Your Honor. I think the may refers to the fact that a hearing is required. So just because you get rearrested on a felony doesn't mean doesn't mean your bail is going to be revoked, because the prosecution has to establish reasonable cause to believe you actually committed the new offense.
I just want to be clear. I may have misheard you. Did you say that risk of flight is also covered under 2A?
Risk of flight is also covered under subsection 2B, Your Honor, and so that is why it cannot be as clear-cut as appellant suggests, that if you're talking about risk of flight, you're under 1. If you're talking about anything other than risk of flight, you're under 2B, because 2B requires courts to consider risk of flight when setting a new securing order.
Thank you.
Thank you, Your Honors.
So is the court limited as to what factors or what evidence it can consider if there is a subsequent arrest as it applies under 1?
No, Your Honor. So long as it is part of a least restrictive means, or now the kind and degree of control or restriction necessary, and risk of flight analysis, and so long as the court is considering appropriate bail factors that are listed under 51010, there is no restriction. And to turn back to Judge Garcia's hypothetical earlier about the defendant who would be subsequently arrested for stealing passports, the respondent's theory is just not workable, because if undoubtedly that would increase that defendant's risk of flight. And if we adopt the respondent's position, then the court would be precluded from engaging in a risk of flight analysis. And if the defendant had done something much less significant, failed to go to a court-mandated program that was a condition of his release, committed misdemeanor offenses, the court could certainly consider all of those factors, as Judge Singas alluded to earlier, under subsection 1 without conducting a hearing. But then suddenly, if the new violent felony arrest plays any role in the court's determination, a hearing is required, irrespective of any consideration of dangerousness. And that cannot be what the legislature meant. It is not what they said in the statute, and at no point here was dangerousness invoked.
But you mean irrespective of any consideration of flight risk, right?
No, irrespective of any consideration of dangerousness. There was no consideration of that here. So long as that is not considered, there would be no need to proceed to subsection 2A. I apologize if that was unclear.
It seems to me that the default position in 2, either 2A, where you commit specified felonies, or 2B4, I think it is, where you commit a felony in violation of a condition, is based on the fact that you committed the crime itself, the new crime, like reasonable. And that alone is enough. You don't have to tie it to appearance. You commit one of those felonies under A or under B4, and that's why you get this hearing, because the people have this burden to show. If you're going to rely on the fact that you committed this new crime, you have this obligation. Seems to me if you're going to go under 1, then you can't circumvent that requirement by relying solely on the fact that the defendant committed a new crime by showing some relation between the commission of the new crime and the factors going to risk of flight. Do you disagree with that?
Yes, Your Honor. It's not a circumventing, and I disagree with the respondent's position that it has to be an either-or analysis. Inevitably...
It's not either-or, but the court can choose. And I think that, there's an argument that the court, despite what the people ask for, can go under 1 or 2. But if the court goes under 1, don't the findings in the record have to support a finding under 1 beyond committed this new crime?
Absolutely, Your Honor, and the findings here did establish that.
I understand that's your
Yes.
position, yeah.
Yes, and here I just want to point out something briefly, that the respondent had highlighted that 2 of these cases were subsequently dismissed. It's important to note the context in which this case was evolving in all of these cases. It was during the COVID-19 pandemic, the height of it, as well as the imposition of the new discovery laws. So things were not operating under normal circumstances, but at the time that the application was made to modify the bail, those certainly were relevant factors. Those cases were pending. And once those cases were ultimately dismissed, the defense had an opportunity to go back to the bail court to say, I'm now presenting this as a basis for modification. Ultimately, remand was still ordered by that court and upheld by the appellate division, but it's not as if the defendant is being denied an opportunity or a meaningful opportunity to present those factors that would weigh in his favor as well. And to briefly address the issue of Section 51030, I don't read that to say that by notifying the defendant that the bail may be revoked under subsection 2 if the defendant commits another felony, that is going to be the exclusive means of the court considering that subsequent offense.
If you had an original, I know you don't hear, but if it was a non-qualifying offense originally, right, and now you commit another felony, can you get remand under 1?
No, Your Honor. Under subsection 1, that is necessarily limited to qualifying because of that last line that was added into the statute.
Right.
So there's no concern there of
So
trying to...
you'd have to go under 2B, if it, or 2A if it qualified.
Yes, Your Honor. And the point that respondent highlighted about the least restrictive means analysis also being incorporated into subsection 2, I think what's really important and critical there is that the least restrictive means analysis only applies to subsection B. It is not applicable to subsection A, which further highlights that that subsection is still the unique section that was added for the courts to consider dangerousness, which is otherwise not permitted under New York law. That's when the heightened due process protection is necessary of this full evidentiary hearing.
What's your response to counsel's point that risk of flight is considered under 2B?
Under 2B, Your Honor, that is under subsection 2D. It indicates that there is some requirement that the court consider the risk of flight and kind and degree of control necessary when it's invoking that section, but it does not apply to subsection A by the plain language of the statute.
But it applies to B nonetheless.
Yes, Your Honor.
Okay, all right. Are you of the mind that if the people did proceed under 2, or if the court, as Judge Garcia is suggesting, decided it's going to proceed under 2, and you were unsuccessful, that you could go back and proceed under 1? Are you able to do that? Is there any limitation on that, given the structure?
There would be no statutory limitation to that, Your Honor, and certainly the people would still have to demonstrate good cause, and there has to be an expectation that the court will do what it's supposed to do.
What's the difference then between those two standards? That the good cause of risk of flight could exist even if you were unable to persuade the court under 2, subsection 2, that there wasn't reasonable cause to believe the crime had been committed?
Well, Your Honor, I think the standards are different because in reasonable cause to believe, we're dealing with the burden of proof and we're dealing with the commission of an actual offense, whereas under subsection 1, good cause is more broadly considered to determine whether there's an increased incentive to flee. The difference is in the hearing requirement, and respondent contends that it is easy in some ways for the people to meet that burden. It's not, in fact, difficult to show that the defendant, that there's reasonable cause to believe that the defendant committed those offenses by virtue of the fact that an accusatory instrument would establish that. The burden comes in with the hearing requirement of Section 2C, and that is significant because not only in the cases that Judge Garcia mentioned where you could have reasons where you may not want to call a grand jury witness, there are other reasons why a hearing may not be practical, feasible, and certainly just not necessary. Sometimes the grand jury minutes are not immediately available, as was the case here. Subsequent offenses can occur out of county, all over the state. So to determine whether this full-blown evidentiary hearing is necessary, there has to be an invocation of dangerousness. And because there was not that here, the court was appropriately modified the bail pursuant to subsection 1.
Thank you.
Thank you.